kidogo tu basi.
Afande, tafadhali hivi tupata tu.
Second, third. Is that the name? Yes. Okay, go on. For the first, second, third, fifth, sixth. For the rest? Yes, for the rest. That is, we go all the way to number 7. Anyone else? For quorum purposes? For the respondents, that is the appearance. Then presence was
pilot hand.
pilot line.
Yes, pilot. Hand. The State Department of Children's Services, Nakuru County. Department of Children's Services for Children's Services, Nakuru County.
The 2nd of June, 2026. Article 49(1) F and G of the Constitution, Article 53(F) of the Constitution, and Section 36A of the Criminal Procedure Code. 36A, Your Honor, of the CPC. Your Honor, the applicant is seeking to have the respondents remand home to enable the DCI conclude investigations. Remand home. Your Honor, the application is supported. Conclude investigations. Your Honor, the application is supported by the affidavit sworn by Chief Inspector Peter Kamau, also dated the 2nd of June 2026. Your Honor, the applicant is undertaking investigations relating to offenses of murder and arson to establish the roles played by the respondents in the fire incident that occurred at Utumishi Girls Academy on the night of the 27th to the 28th of May 2026. That resulted in the unfortunate loss of 16 students. Your Honor, our grounds that in support of the application are that the investigators are currently waiting for critical, forensic, technical and structural reports from various government agencies and therefore will require time to receive these reports and analyze them. Secondly, Your Honor, following this incident, the school was closed indefinitely and the students released to their parents. Meaning therefore that potential key witnesses in the matter are now located in diverse parts of the Republic, requiring now time for the investigators to trace them for purposes of recording their statements. Thirdly, Your Honor, preliminary investigations have demonstrated a likelihood of interference, by the respondents Fourthly, the respondents are facing serious offenses and the incident Your Honor, has elicited public outrage, thus placing the safety and the lives of the respondents in imminent danger if they are placing the safety of the respondents, safety and lives of the respondents in imminent danger if released on bail or bond. Your Honor, the prosecution is alive to the provisions of Article 53F of the Constitution that provides that a child should not be detained except as a measure of last resort. Similarly, the Children's Act provides for consideration of the best interest of the child. However, Your Honor, we submit that the principle must be interpreted on a case-by-case basis. And in this instance, the safety and security of the respondents is key, especially after the release of the CCTV footage. Security of the respondents, especially after the release of the CCTV footage of the incident going viral on Wednesday. For those reasons, Your Honor, I pray that this honorable court finds that the reasons we have advanced are compelling enough to warrant the detention of the respondents for a period of 30 days at the Nakuru Children's Remand Home for their own safety and security, and also to enable the investigators finalize on their investigations. We also believe that it is in the interest of justice and within your discretion, Your Honor, to grant the orders that we have sought. Maybe advocate for victim.
We can begin it.
Mr. Coach, let's hear it fast as well. So when you are responding, you can respond.
We agree fully. We stand guided. We think that is the way to go.
Victims as well, then you can respond.
Thank you, Your Honor.
Fair enough. Your Honor, on behalf of the victim's family,
We equally are in support of the application.
dated 2nd day of June 2026. And in considering this application and based on the Victims Protection Act, and more specifically, sections 4, 9, and 10. We urge the Honorable Court to take into account the magnitude, the nature of the offense, and public health. In balancing the rights of suspects, as against those who are not capable of appearing before you, we urge the courts to take into account the stakes and the necessity for adequate investigation to be completed. And I request before is one, that we find it necessary and just in the circumstances. Lastly, we are wish to highlight the prejudice. The prejudice that been sustained on the part of the victims of their families, if the request is disallowed. This is a matter that needs to and it cannot be obtained if the rules of justice are allowed. To take the unnatural course of action. Permit the investigators to complete the investigations. Obtain any necessary information that may be required. It is not a request that prejudice is suspect before. It's allowing the application prejudice to the victims of the families.
In the prosecution and my counterpart for the victim. Your Honor, we pray that you are guided by the provisions of Article 27, Article 28, and Article 50 of the Constitution of Article 27, 28, and 50 of the Constitution of Kenya 2010, which upholds and provides for the upholding of the dignity victims. Your Honor, the application before you is basically one that, if allowed, will not only uphold the dignity of the victims, but also be indicative of justice for the victims of the incident that is the subject of this application. Your Honor, as we support the prayer for the granting of the 30 days order, we also pray, Your Honor, that the victims, through their families, be made part of these investigations, such that every report, every action that is taken within this period that the court might grant be also made known to the victims. Without Your Honor's support. Thank you. My name is Andrew.
My first time seeing it, so let me remind myself that I will be it.
Yes.
Is it?
Yes, that's correct. You are here for the first, second, third, fifth, sixth, and seventh. Sixth and seventh. Yes. Now we've seen the application dated 2nd of June 2026. And the starting point is that the application is opposed. And I demonstrate why we oppose the application. Now the beginning point is Article 53F of the Constitution. Article 53F. 53F of the Constitution, as read with Section 223 of the Children's Act 2023.
Section
223. Your Honor, those two provisions of the law do not require pre-trial detention of minors. And when I read this application, it is actually ridiculous, because the prosecution is trying to ask you to violate those two particular provisions of the law. So as a starting point, this application does not disclose any compelling reasons.
So you're saying as a starting point, it is ridiculous that prosecution is somehow
to violate Article 53F and Section 223 of the Children's Act. They are simply looking for pre-trial detention without any charges being preferred against the minors. Your Honor, there are no compelling reasons compelling reasons which have been advanced why the minors should actually be detained. And I demonstrate each. So, number one, as you read this entire application,
there is no allegation that minors are at flight risk. So at least that is ruled out. Number two, Your Honor, the prosecution says that the deponent of the affidavit, says that various government agencies are involved in the investigation, and the process will take some time to complete. That's paragraph 5 of the supporting affidavit for that application. Now, Your Honor, the question you ask yourself at that point, if you release these minors, are they going to interfere with government agencies not to conduct investigation? And the answer is no. Your Honor, the potential witnesses in this particular matter, they could be adults, either teachers or whatever. Are they saying that these minors are going to exercise and give influence against those potential witnesses so as to interfere with the investigation? And the answer is no. The question of the prosecution have indicated correctly that the school is closed indefinitely. And the students were released to their parents. Utumishi is a school in Kenya with children from all over the country. Now, does the prosecution try to tell you that these children, if you release them, they are going to those separate homes, look for the other children, convince them not to come and testify against them? It's ridiculous. The school has been closed.
Children can come from all over the country.
Yes. Now, it's not possible for these minors, they lack the resources, they lack the means, to be able to go around the entire country.
You say the children are not respondents?
Yes, that's what I mean.
It's not possible for the respondents
Yes.
to have the means,
Both financial and other means, to go around the country, look for potential witnesses, either from the student population or parent population, and convince them or interfere with the investigations in anyone. It's not practical. Another reason in that application is that the matter has elicited public outrage. And Your Honor, will allow me to draw an analogy. The last time history teaches us that public outrage was used in a trial of Jesus of Nazareth, the trial was unfair. Because Your Honor, what Pontius Pilate did, he saw his innocence, but nonetheless he washed his hands and said, if the man wants you, take it. It shows how fair it was. Therefore, Your Honor, public outrage cannot be a reason to violate the minor's rights. Your Honor, closely related to that is that because of that public outrage, they say that the safety of the person, the respondent, is in imminent danger. Your Honor, nothing can be further from the truth. Even the court as we speak today has not looked at the man, does not know who the respondents are. The police did a fantabulous job together with the Children's Department. The identities are not disclosed to the public. So how is the identity becoming an issue that now if they released, their safety to their person will be prejudiced? Your Honor, that's a red herring to ensure that these minors' rights are actually violated. And Your Honor, we ask the court to sieve out that needle of truth from this haystack of lies and obfuscation contained in this application together with the supporting documents. Your Honor, the likelihood of interference in any investigations has not been disclosed whatsoever. They continue with the education, they have a right to education. And when the prosecution asks for 30 days, surely we are not in a banana republic. There is the rule of law. The best interest of the child does not require any such pre-trial detention. These children are not in a common place. Even the other learners, whom the respondents can go and tell that, no, let us intervene in the investigations in this way. It's not possible. Some kind of warped reasoning violate the rights of these minors, and Your Honor, with those submissions, we oppose the application and pray that you grant the release of this particular minors. Thank you. Thomas, Madam, this is decline this application.
Your Honor, on behalf of the 4th, 8th, and 9 respondents, together with their parents and their parents, we wish to stand in solidarity with the victims of this sad incident and Kenyans at large, and convey very sincere condolences to the families, relatives, and neighbors of the 19 children who lost their lives. There were reports filtering in this morning because we are following that there could have been more deaths. Yes, children who may have lost their lives because of the infant that raised to the school, Your Honor. We also wish the many children who are undergoing treatment quickest of recovery. And my clients and their families stand with them during these very difficult times, Your Honor. It was very professional of my colleagues from the ODPP with the investigating officer. Permit me, Your Honor, I would now proceed to the meat of the matter. Your Honor, you are invited by the prosecution, ODPP, the investigating officer. The respondent contacted. Permit me, Your Honor, I would now proceed to the meat of the matter. Your Honor, you are invited by the prosecution, ODPP, the investigating officer. Permit me, Your Honor, now proceed to the meat of the matter. Your Honor, you are invited by the prosecution, ODPP, the investigating officer. Or cash bail. Whether investigations have been completed or not. And Your Honor, there is only one issue that should engage the mind of the court as to whether a suspect should be released on bond or not. And that is one reason, Your Honor. The absence or presence of a compelling reason very amply, Your Honor, we submit that the prosecution has not established a compelling reason. Your Honor, you've been told that there are a multi-agency operation. This could be true. What Your Honor has not been informed sufficiently is what would be the role of these children in the ordinary operations of the DCI, for example. Can they interfere with the government chemist? Can the children interfere with the Ministry of Public Works? And the answer, Your Honor, is that it's not possible for these children to interfere with these government agencies. You are told that there are many children released after the closure of the school. The correct number is 800 children. How can 9 children, Your Honor, shooting into the dark because we don't know how many of them are witnesses, where they live in, where there are homes. Do these suspects have their contacts? Like my colleague Mr. Mugira has said, that suggestion that these 9 suspects could interfere with 800 girls out there in Wajir, in Homa Bay, in Tiati, can be interfered with. It's not just a timid suggestion. It is a wishy-washy suggestion, Your Honor, and it will not derive a compelling reason. On public outrage, like Mr. Mugira said, the proper panacea, the right treatment for public outrage is the rule of law, constitutionalism, and due process. Justice will not be served through pretrial detention. The victims, we respectfully submit to Your Honor, will not get justice through pre-charge detention of 30 days. What happens when they come after 30 days and say we are dropping 5, 6, or all of them? They shall not take plea because there is insufficient evidence. Because they would have been detained through a court order, they would have no compensation for violation of their right to liberty, Your Honor. This being a senior court and a very fair court, please take note, Your Honor, that public outrage is an unruly horse. It should be served with what the Constitution provides and the rule of law, not through pre-trial detention or pre-charge detention. I will adumbrate my submissions with 2 decisions. I have shared, unfortunately I didn't bring hard copies, but I have shared one decision with Madam Okok through WhatsApp. This is a High Court decision which is reported. This is the case of, I've also shared with Mr. Wairegi, who has already read it, the case of Oscar Kipchumba versus Republic. Kenya Law Reports Electronic. And this is 2020. I can avail a copy after this. And Professor Joel Ngugiasi then was considered similar issues, security of the suspect, and Your Honor, the court made it very clear that it is the responsibility of the security apparatus of this country to secure suspects, secure witnesses, and they can't use that as a compelling reason to deny bond. I had already invited Your Honor to dismiss the wishy-washy application on interference with witnesses. This issue also of suspects being harmed by undisclosed members of the public is not a compelling reason. In any event, remand institutions are not meant to provide securities for people who are under threat. They hold people who are going to do trial. The suspects here are not going to do trial. Investigations have not been completed. It's only the IO who thinks that they might go through the process of trial for murder and or arson. Is therefore, Your Honor, underwhelming to suggest that you use the issue of want of security as a compelling reason. The parents are here, they have committed to take care of their children as parents, involve counselors where necessary, and ensure they are in court as and when required. At paragraph 24 of that decision by Justice General Maura Ngoge J.S. then was, Your Honor, the court held that, I know Your Honor is studious and you have an occasion to go through this. The court held that the state must persuade the court that it is acting in absolute good faith and that the continued detention of the individual without a charge being preferred, whether provisional or otherwise, is inevitable due to existing exceptional circumstances. Your Honor, there is nothing exceptional. These children have no access to DCI. They have no access to the government institutions or even the school. The school has been closed. They can't access the 800 children from Utumishi Girls Academy. Let the investigations run. Grant these children bond and or cash bail. If they are supposed to, if the court directs they report every 2 weeks at the DCI in Nairobi, Naivasha or Nakuru, the children will comply. Clause B of paragraph 24. Your brother, Justice Ngugi, said that the state must demonstrate that this kind of pre-charge detention is the least restrictive action. Not want to rehash what the High Court said. That was Oscar Sudi, an ordinary, a member of parliament and an adult. When you look at Article 53, F of the Constitution, the options for detention now become very, very limited. there has to be an idiosyncratic reason, a very unique reason. None has been demonstrated, Your Honor. And finally, Your Honor, Section 4 of the Children's Act, which adopts the United Nations Convention on the Rights of the Child, guides this court to consider the best interests and welfare of the child, even under such circumstances. And in fact, Your Honor, under sections 186 and 187 of the Children's Act, which are very familiar to this court, detention of a child should be the last resort. What is then our ask, Your Honor, if you are persuaded not to allow this application? Our ask as respondents and parents, Your Honor, is that you strike a balance. Please admit these children to bond on such reasonable terms, Your Honor, as you may deem fit. The parents and the children will not interfere. They will not reach out to any other child or parent from Utumishi Girls Academy. They are willing to present themselves as and when required in any police station, as this honorable court may direct. And if push comes to shove and they have to take plea, because that is the ultimate station in criminal proceedings, they are more than willing, Your Honor, to attend court and comply with such directions and orders as the court may direct. Your Honor, please decline this invitation to bring back pre-trial detention, pre-charge detention. Decline the invitation, Your Honor, and adopt a progressive approach where justice is served for victims, for suspects, and for the rule of law. Your Honor, you will, when you retire, you will consider this decision on children. This is JMK and 9 others, JMK and 9 others versus Republic. This is NLO Report 2014. We know each other, Your Honor, good friends.
So, Your Honor, we'd like to make a rejoinder in the matter as follows. First and foremost, that you have been made to refer to acts.
Yes,
Section 223 of Children's Act and Section 4 of the Children's Act. Of importance to note that, Your Honor, in those sections that you've been referred to, as well as the provision of the Constitution, it seeks to address the question of the best interest of the child, which the defense, in their response to the application before you, they have sought to invite you to look at this application as being one that does not consider the best interest of the child, and therefore the respondents before you. To indicate and demonstrate clearly before this honorable court that the best interest of the child and the respondents for this particular case cannot be overemphasized, if not as it is contained in the application before you. As nobody can state that they are preserving the best interest of the respondents if we do not preserve their security and safety. And Your Honor, it's now in commonplace that best interest of the child may not be necessarily what interests the child. What the defense has advanced and requested you is most likely what will interest the respondent. You've been also, Your Honor, invited to consider the fact that the prosecution has not advanced any compelling reason to warrant this honorable court to consider pretrial detention. Your Honor, as you may know, the prosecution does not require to prove all available compelling reasons to warrant a court of law to consider pretrial detention. Your Honor, compelling reasons have been laid down by various decisions of superior courts. And one celebrated law as a classical of this particular area of law is the celebrated case of Republic versus Jackton Maende. The state can advance.
Your Honor, with tremendous respect, I think what my learned friend could do is only refer you to the decision.
I know why he's bringing it, because on several occasions I've had to deal with these matters before me here, and it's because in Dr. Mayanda, they laid out what juridically would be compelling. You can actually Google it as we are going on, so that if there is a point where you may need to reply, because the mere existence of case law that not necessarily the application is about is just reflecting on what has been decided.
Much obliged. I was only of the view that he could just refer to the decision without going back to the facts.
Not the facts, he may need to highlight what that decision is about. I think someone stopping from that because you raised the issue of compelling reasons.
I stand guided.
Your Honor, the court listed a number of compelling reasons, and what interests to me in the matter is the fact that the court addressed the question of the security and safety of the respondent. Your Honor, you've also been invited to look at the fact that the respondents are not a flight risk in the consideration of the response by the defense. And it is our submission that the application before you and the pretrial detention as it is now that forms the basis of this application, it's not only just a functionality of a flight risk. In addressing the question of interference of witnesses, the defense has also invited you to the fact that the respondents have no means or ability to be able to interfere with witnesses. However, Your Honor, counsel has also clearly demonstrated to you on behalf of the respondents that these particular students in this school, Utumishi, they live all over around the Republic of Kenya. And in showing that they cannot interfere with the witnesses, they have also not demonstrated that these particular students could not be neighbors to each other or known to each other, and therefore bring in the question of interference. And therefore, Your Honor, the defense cannot invite the court to ignore the demonstration by the way this court is packed and so many people even outside there. The court can take even judicial notices on the fact that there is a clear public outcry that cannot be ignored just because during the trial of Jesus it was wrong and it led to a wrong finding. I don't know which tribunal sat on that. The court can also even take judicial notice that there has been special arrangement in terms of security for this proceeding even to proceed today. If that does not mean anything in terms of what public outrage is, then definitely, Your Honor, I don't know any other possibility that can be able to convince any person properly directing their mind on this matter with regard to what is public outrage is. Counsel has also averred to, in his response, has also referred to the question of the identity of the respondents having been concealed, both inside this court and even outside the court. And the reason the identities have been concealed before this court is known because it's a matter of public policy and the law that the identity of the minors appearing before court must be concealed. But it will interest the court to know that that identity is not only concealed before this court, it has also been concealed even outside the court. And what counsels have not addressed you in their opposition to this application is that the reason for concealing the identity of the respondents outside this court, it's again to protect their safety. You've also been invited to look at what will be the role of the respondents. And according to the defense, you've been informed that they have absolutely no role. That again, Your Honor, cannot be far from the truth. But then if the court is invited to take that approach, then the court will be invited to take a narrow approach instead of taking a holistic approach of the entire matter, which does not just rotate around the role or the involvement of the respondents before you in the pendency of the investigations. In the case of Oscar Sudi, which you've been invited to look at when you retire to consider this matter, I need not even re-emphasize that particular case because Council has done the work for me, and I will just simply add the cherry on it. Council has simply invited you to the fact that the court did not say that there should be no pre-trial detentions. In fact, reading of all that decision, you will be able to appraise yourself that the court was alive to the fact that there will be pre-trial detentions. And that's why the court said there has to be exceptional circumstances. If what we are faced with today is not an exceptional circumstance, where we are faced with a situation where 16 lives now, even with the update from the bar, we are now told we are at 19 lives, young lives which were lost, and the circumstances surrounding the complexity of the investigation in the matter, then it does not form exceptional circumstances to warrant us to come into the purview of what Professor Justice Ngugi was referring to in the case of Oscar Sudi. Then again, I do not know what exceptional circumstances should be. Again, that court in that matter referred to the question of restrictive, as detention to be a restrictive last resort. This is the last resort. Going by the facts and the grounds that have been laid down in the application by the investigating officer, we on the side of prosecution, we do submit that we have no other option. This is the last resort. That the respondent, in their own best interest, in the interest of the victims, and in the interest of these investigations, there has to be a pretrial detention. Is that pretrial detention in the best interest of the minors? Yes, it's in the best interest of the minors, Your Honor. We are not saying these minors be taken to a GK prison. We are saying they be taken to a remand home. Were the remand homes created for adults? The answer is no. They were created for children who are in conflict with the law, such as the respondents before you, as a last resort, which again, Your Honor, we have submitted. This is the last resort, allegedly.
There's no submission with respect to the ages of the respondents. But do you have future cover? Yes, do you have the specific birth certificate or proof of ages? Yes. So you have all the proof of ages. Yes, and the children. So we have the ages. That documentation is provided to them. So this must be important. You receive the documentation. Because I cannot tell that they are children without proof of age.
No, we are actually under the impression that the report from the children's office has already been given to the court.
Is it in evidence?
Because it ought to have a final.
No, that is usually under different circumstances. Because there are too many eyes. Usually they ask the respondents how is their, and if there is any proof. And now if I do that, then I will be infringing. I'll be going against my regulations. So, to connive the documents.
Yes, Your Honor. We do have a birth certificate.
Please avail them to Martin. Martin is the sister. So avail them so that then I can be used to it. I intend to make this ruling as fast as possible, so I'll make it tomorrow at 2 p.m. Tomorrow at 2 p.m. Where do we hold them today? Where they have come from. Yes, I will not know where they have come from, but where they have come from. Go ahead. You are certain now that you will understand there is no possibility of being held with us.
That is what we are fighting for, because I come from Nakuru and I know what they are doing about Nakuru children. That is in order. One request, Your Honor, that I would make is I be allowed to access the 3 respondents that I represent.
Also accessing the children. Let me get it from both the IO or the IO. Any objection? So, what it be first? No objection. Only the council. Council you can access. Council you will be able to access. And through new photo, the new photo is here together with the
Okay, thank you.
So you both I'm actually going to present them.
Thank you.
So now I'll deliver at 2 p.m. 2 p.m.
We are marching.
I'll deliver it with this call because they must appear in court. Alright? Or do you want us to do it online? Okay, so we do it in person. Alright, so further, so required. Our usual business here in Naivasha.